Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. In the case of Parking Eye Limited versus Beavis, Mr Beavis challenged his fine for £85 for overstaying the permitted time in a car park as being a penalty charge and therefore unenforceable. It has been established law for over 100 years that penalty charges are not enforceable under English law. Most lawyers will define penalty charges as something that is not a genuine pre-estimate of a party's loss. But what is often forgotten to be considered is that to be a penalty charge, it must also be extravagant and unconscionable. In this case, Parking Eye at the Court of Appeal successfully demonstrated that the charge was not extravagant or unconscionable. It had clear warning signs and the fine was set at a level for considered social factors, such as having a deterrent effect. We think that this case is interesting to any business that includes charges for contractual breach. It's clear that there is more scope to permit such charges than is suggested by the often oversimplistic definition of a penalty charge. Naturally, it is still unwise to refer to them as a penalty, and other good, careful drafting practices are still advisable, such as clearly separating the charges provisions to minimise other causes being caught if they are struck out. In March 2014, the Northumbria Trust accidentally sent faxes concerning several patients to a member of the public rather than the intended social care team. The Trust took sensible action following this breach by programming the fax machines to only use pre-stored numbers. Regretfully, this was not communicated fully across all wards and faxes were again sent to the same member of the public. It was also found that the Trust was slow to react and did not immediately try and recover the documents. The ICO has now subjected the Trust to an undertaking to ensure that all concerns are addressed. This case does demonstrate the importance of getting your house in order once there has been an incident and not allowing there to be a reoccurrence of the same issue. The Advertising Standards Authority, the ASA, and the Committee of Advertising Practice, CAP, have been busy in the past month pushing out new guidance on how to keep your advertising on the right side of the line, including 1. Guidance on the use of swearing or sound-alike swearing in advertising, 2. Guidance concerning comparative advertising, and 3. 6 top tips to avoid misleading advertising. There is nothing new or surprising in these guides, but nevertheless they are succinct guides to the relevant parts of the advertising law. In addition, CAP has changed the provisions of the UK Code of Advertising that affects sales promotions, which is Section 8. The changes follow a consultation in 2014 and aim to ensure that the rules remain consistent with the Unfair Commercial Practices Directive. The new rules became effective on the 1st of May and the ASA is now seeking to enforce compliance with them. We've included the links to the guides in our written version of this report and they can be found on the CAP website, which is shown on your screen now. We've now had the long-awaited decision relating to collective redundancies, the lead case being Woolworths, which demonstrates how long this case has been trundling along. Those of you who have been following it will recall the issue is over the definition of establishment. It is clear that when 20 or more employees are made redundant in a 90-day period from an establishment, then collective consultation must be undertaken. But whether establishment means the entity to which the workers are assigned to carry out their duties or across the whole employer has not been clear. It has now been confirmed that it is the entity where the workers are assigned to carry out their duties, e.g. an individual retail shop rather than all the shops in a chain. This is good news for employers as evidently collective consultation is less likely to be required. Some of the unions are now calling for a change in the law. Last month we spoke too soon when we reported that we were heading towards a conclusion on the long-running saga concerning holiday pay. The issue being whether employees should be entitled to normal remuneration, including average commission during holiday periods. However, the tribunal decision in the lead case, Locke versus British Gas, has now had an appeal lodged by British Gas. To recap on the history, in October 2014, the Employment Appeal Tribunal ruled in the case of Bear Scotland v Fulton that European law can be carried over into the Employment Rights Act of 1996, therefore requiring employers to take into account non-guaranteed overtime payments when calculating pay for the basic 4-week holiday entitlement. In March this year, the Employment Tribunal reached the same conclusion in relation to commission in the Locke versus British Gas case. The appeal is on two grounds. Firstly, commission and non-guaranteed overtime are dealt with under different provisions which use different language. Accordingly, the tribunal incorrectly concluded that Bear Scotland, a case about overtime, had any bearing on the outcome of Locke. And secondly, in any event, the EAT in Bear Scotland incorrectly concluded that UK law could be interpreted purposive to give effect to European law. The appeal could, therefore, have a wider effect than the current commission case. The appeal is likely to be heard towards the end of this year. The Home Office issued new guidance for employers in May this year for carrying out right-to-work checks. You can find the link in the written version of this report. It is a helpful guide as it clearly documents the processes to be followed and documents to be obtained to ensure you do not fall foul of the law. The consequences of breach are severe, with penalties of up to £20,000 for each illegal worker employed, imprisonment and unlimited fines for any knowing employment of illegal workers. And don't forget that you'll be liable for any illegal employees that cheaply transfer to your business. So it will be important to ensure that the appropriate checks have been done by the former employer before you acquire the business. In Vertical Leisure v Poleplus, an employee of Poleplus, Mr. Bowley, registered domain names incorporating the term Silk2, which was the name of the product produced by Vertical Leisure. Mr. Bowley admitted that his intention was to make some money from the domain registrations and had offered to sell them to Vertical Leisure. In an earlier judgment, it was held that the registration of the domains constituted passing off, and the issue now was whether Poleplus was jointly liable for Mr. Bowley's actions. It was held that Poleplus was jointly liable, as Mr. Bowley's primary intention was the protection of the interests of Poleplus, and that his actions in registering the domains had been within his authority as an employee. This case therefore illustrates the importance of staff training to avoid the risks of companies being dragged unwittingly into passing off and trademark infringement actions. The European Commission launched an antitrust competition inquiry into the e-commerce sector on the 6th of May. This follows concerns expressed by the European Commission that although e-commerce generally has seen significant growth in recent years, cross-border e-commerce is growing relatively slowly. This concern is backed up with some evidence. The fact sheet that has been issued by the Commission notes that while 50% of EU populations had shopped online in 2014, only 15% had shopped online from a provider based in another EU member state. In a separate report, it has been noted that 32% of retailers identified contractual restrictions in their distribution agreements as being the reason for refusing to supply cross-border. This is likely to be the issue that the inquiry will focus on. If your business operates with distribution agreements, are there restrictions in your contracts that may prevent cross-border trade within the EU? Even if the contracts do not prevent cross-border trade, what happens on the ground? Our experience is that in many cases the contracts permit cross-border trade, but in practice there are restrictions, often simply because the business folk are not aware that they are breaching the law. We have seen investigations and fines from previous inquiries, so although this inquiry will rumble on for some time with a preliminary report not due until mid-2016, we recommend that if relevant to your business, you review the wording of your contracts and the practices now. Last month, the government introduced new consumer hire and hire purchase agreements legislation. The legislation extends the scope of the limited permission regime to cover all broking of consumer hire and hire purchase agreements. This is good news for business as it helps to ensure they will only be subjected to the less burdensome regime that the limited permission permits. Thank you for joining us for this month's Commercial Legal Bulletin. The videocast and podcast are available to download on the website, together with the written report. The website details of Radius Law and LexisNexis will be shown shortly on your screen. We'll be back next month with another update. Until then, thank you and goodbye.